This coming election in November 2024, Utah has 4 constitutional amendments on the ballot. Today we're going to look at Amendment D to see a little bit more about this amendment. If you've watched the other 3 amendments so far, they're shorter videos. This one will be a little bit longer because Amendment D is fairly complicated. There's a lot going on here, and it's important to understand some of the issues so that you can make an informed decision on this. I will admit that this amendment, voting yes or no on it, is not super clear cut for a lot of people. There are problems, I believe, whether you vote yes or whether you vote no on this amendment. But to give a little bit of background on it, in 2018, I believe it was, and I could be slightly wrong on the year, but Utah had a number of ballot initiatives on the ballot. This meant that citizens had gone and collected signatures and said we want to pass certain laws. This is when we had medical marijuana, Medicaid, and gerrymandering initiatives. And the one that's of particular interest to us is the gerrymandering one. Essentially, the ballot initiative said, we don't want the legislature to redraw district boundaries. They knew that in 2020, the census would take place, and that based on population changes, districts would have to be redrawn to help the districts be equal or approximately equal again. And so in 2018, this law was passed that said, it was passed by the citizens to say, we don't want the legislature to redraw those because traditionally in the past, the districts look pretty funny. They tend to split up certain votes, such as really carving up Salt Lake County with Democratic districts and things. And we just want it to be based more on natural lines, roads, cities, county lines, rivers, if there's a river by it, when people don't talk to each other on either side, put them in different districts, that type of thing. And so this ballot initiative passed. And in the legislative session following, the Utah legislature made some changes to it. And instead of keeping I guess to back up a little, sorry, the bill or the ballot initiative that had passed established an independent redistricting committee. And this independent committee was supposed to draw the lines. But the legislature changed that to say, we'll make you an advisory committee. You can submit a proposal to us. But at the end of the day, we're going to be the ones that still choose what we do. So after the census in 2020, the Utah legislature gets the proposed district back from this independent commission, and they decide we don't like it, and they drew their own districts. This current election in 2024 is currently using those districts that were drawn by the legislature. And so what happened after that is a group of people, there's a number of groups that sued, and they said that was unconstitutional under the Utah State Constitution for the legislature to change this ballot initiative. In the past, the legislature had changed any and all ballot initiatives it wanted, and it would consistently make changes to things that came through from citizen initiatives. And so I think most people were expecting that the legislature would still have power to do that. However, the Utah Supreme Court, in a case in July, came out with a case that surprised quite a few people. And this case is what's at issue in this Amendment D. Now, the text, and we'll read this in a little bit, where Utah's telling you what you're voting for in Amendment D, it's not as open or transparent as I believe it should be, because what they're doing, this whole Amendment D came in complete response to the Supreme Court case. And they put it on the ballot even in a special session after the Supreme Court case to try and allow you to vote on it this election rather than waiting, because they're concerned about implications from the Supreme Court case. So if you look at the Supreme Court case, this is the case, League of Women Voters of Utah et al. Means there's other parties involved, versus the Utah State Legislature. So if we scroll down a little in the case, we'll come down to some areas I highlighted. And you can look at these, they follow the paragraphs. Utah numbers their cases by paragraph. The Utah Supreme Court states that under our state constitution, the people's legislative power is equal to the legislature's. So to break that down, the legislature passes laws. Under the state constitution, the people can also pass laws. They have equal power to pass laws. They just go through a very different process than the legislature. But at least constitutionally, it's stated to be equal. The legislature exercises its power by passing laws during legislative sessions. The people exercise their power by voting during elections on initiatives that have qualified for the ballot. So these are ballot initiatives. If the people approve a proposed initiative, it becomes a statute in the Utah Code. And that's what happened again with the gerrymandering ballot initiative. It became a statute, became law, and then the Utah legislature changed it. But the Supreme Court notes that in paragraph 3 of their decision, Article 1, Section 2 of the Utah Constitution has what they call the Alter or Reform Clause. And this states that the people of Utah have the right to alter or reform their government as the public welfare may require. And I just realized, sorry, that I was not sharing this window. So let me pull it up here. So this is what we're looking at here as we talk about this case here, League of Women Voters of Utah versus Utah State Legislature. And then in the paragraphs here. So since the Utah Constitution stated that people can alter or reform their government as the public welfare may require, the question arises, this is paragraph 4, the novel question before us, and novel means new, they haven't heard this question yet in court, before us asks, what happens when Utahns use their initiative power to exercise their right to alter or reform their government by passing an initiative that contains government reforms, and the legislature repeals it and replaces it with another law that eliminates the reforms that people voted for? So to think about this, to try and put it in context, is the people of Utah voted and they actually took a power away from the legislature through their ballot initiative. They said, legislature, you no longer have the power to draw your own districts for voting purposes. We're giving that to this new independent commission that's been created. And the legislature then said, hey, no, we still have the power. We'll just pass another law and take the power back. Haha. And essentially then the Supreme Court's looking at this going, if the people of Utah have the right to alter or reform their government, how can they do it other than through voting? And if they do it, if they exercise it and actually say, government, you no longer have this power, then what happens? And so that's the question here. And so attorneys argued over this. They fought back and forth on how this should turn out. And ultimately, if you come down to paragraph 11, and this is a long decision, the court goes on for quite a long length of time to explain its reasoning, but paragraph 11 gives you a summary of things. It says that we hold that when Utahns exercise their right to reform the government through a citizen initiative, their exercise of these rights is protected from government infringement. This means that government reform initiatives are constitutionally protected from unfettered legislative amendment, repeal, or replacement. Although the legislature has authority to amend or repeal statutes, it is well settled that legislative action cannot unduly infringe or restrain the exercise of constitutional rights. Consequently, when Utahns exercise their right to reform the government through an initiative, this limits the legislature's authority to amend or repeal the initiative. This does not mean that the legislature cannot amend a government reform initiative at all. Rather, legislative changes that facilitate or support the reform, or at least do not impair the reform enacted by the people, would not implicate the people's rights under the Alter or Reform Clause. Legislative changes that do impair the reforms enacted by the people could also survive a constitutional challenge if the legislature shows that they were narrowly tailored to advance a compelling government interest. So there's a lot here. Ultimately, a very important thing to know is that the Utah legislature was very upset by this decision. They were quite appalled by it, which is why they kicked into a special session, voted to not only put this on the ballot, but they had to change the statutes to make it so they could put it on the ballot, because normally they were past their time to put constitutional amendments on the ballot for this coming election. But to break it down a little bit, there's a lot in here that's probably hard to understand if you're not an attorney. So because they actually talk about some legal principles and not just saying the words some of the words are discussing certain principles and have legal meaning to them. So when we look at this, they say here that the legislature no longer has unfettered legislative amendment, repeal, or replacement power. So they can't simply just do away with it. They can't say, we just take the power back that you took away from us. Now, they did say, though, that the legislature could still change it if it supports the reform or at least doesn't impair it. So if they're changing the law a little bit to, maybe say, I don't know, just thinking of if they say this should be funded from sales tax, and then the income tax amendment passes and the legislature says, okay, we're going to fund it from sales tax and income tax, then that would be something that would probably support the initiative because it now has more funding sources. So that type of amendment would be allowed. And again, most probably wouldn't be upset about that. At least I'd say most that supported the initial initiative wouldn't be upset by that. Those that were against it might be opposed if that, increased the power or supported the initiative that was passed. But they also say here at the end that legislative changes that do impair the reforms, so if you go and actually change it to take away what the people said, it could survive a constitutional challenge if the legislature shows that the changes were narrowly tailored to advance a compelling government interest. These are legal terms that are used in constitutional interpretation. And there's not a lot of things in the past that have been found to be narrowly tailored to advance a compelling government interest. And what this means is that the changes were necessary and the changes were just limited to the very little thing that was necessary to accomplish something that's considered a compelling government interest. Now, again, if you look through case precedent, case history, there's not an intense number of things that have been found to be compelling to the government. The government has an interest, for example, in regulating order, but that alone isn't compelling. Compelling is usually something of the highest and most importance. So the government has a compelling interest in stopping racial discrimination, generally. But even if it's going to pass a law to stop racial discrimination, the law has to be narrowly tailored, meaning the law itself is only focused on accomplishing the purpose of stopping that discrimination or stopping that compelling interest. So in this situation, if the courts were to ask the government, say, well, why did you change it? Why did you take away the redistricting power? Their answer would be, we didn't like it, or they drew bad districts or something. But that wouldn't necessarily be a compelling governmental interest. It would be one that it'd say, well, that's more a political thing that was up to the people. The people wanted bad districts, they got bad districts. And so the government wouldn't be able to show a compelling interest, and they also probably wouldn't be able to show that it was narrowly tailored. There's always two parts to that. Now, you might be able to show that something was narrowly tailored and compelling if, for example, people passed a law that said, we want Utah to give us $1 trillion. Then the government could say, well, from a compelling perspective, it would bankrupt us. We don't have that kind of money. And the Supreme Court of Utah would probably agree and say, yeah, it's pretty compelling that you need to keep your state from going bankrupt. So you can change that initiative to have that balance in place. But absent that, there won't be a ton of things that are changing the Utah government that would be able to be changed by the legislature if this case remains unchanged. So what this does essentially is it gives the people kind of a veto-proof ability to change a lot of Utah's government and to alter or reform their government. Now, some people say this is a new power. Others point to the fact that the Constitution had its clause in it for a long time. But again, it wasn't ever heard and had never been tested in court. And so now we're at this place where the legislature is saying, whoa, if a ballot initiative can just change things, then foreign governments could come in and they could run an initiative and make it so that we have become communist or socialist or whatever else these other countries want Utah to become, and we wouldn't be able to do anything about it. And there's a number of people that believe that when there's big money that comes in behind a ballot initiative, the initiative passes because they get enough ads for it. They get nice sounding marketing for it. And many people believe that Utahns don't fully investigate or look at things. And so they think the ballot initiatives tend to follow the money. So those people that are worried that the ballot initiatives follow the money say we've got to amend this quickly and make it so that the legislature still has the ability to check and balance one of these amendments that comes through. From my perspective, when I look at it, the other side to this is saying, well, if the legislature wants power back, or they want the ability to be a check and balance on the citizens and what the citizens pass, from my perspective, the citizens also want the ability to be a check and balance on the government. And one of the big things that's been happening in Utah and nationally, there's been a lot of push about election issues. Now in Utah, we don't have, to my knowledge, we don't have, concrete evidence of things being good, bad, or somewhere in between. We do have issues that could exist and that may exist, but we don't have a lot of transparency or accountability in the election process. And most of these voting records are protected as private records. Now, again, there's reason for our votes to be private. We don't want to lose our job because of how we voted or who we voted for. But there's also a lack of accountability quite often. And this is worrying people. And so the elections are the way that citizens are supposed to be a check and balance in a republic on the legislature and those that have voted for. So from my perspective, if we're going to give the legislature power back to vote on these things and to be a check and balance, the citizens need to be guaranteed that they have a strong check and balance power too, and that elections function as they should. And there's many things that Utah can do to help clean up elections and to make the process more transparent, more full of accountability, more checks and balances in place. And if we can be rest assured that we have good quality elections, the Republic has a lot stronger basis to exist on. And our government does as well, because then there aren't questions about whether it was valid or not. And so from my perspective, we can do a lot in our society by increasing this. But if we simply give the power to the legislature and say, yeah, go ahead and amend anything, then we lose this potential for a check and balance back. And they just say, well, trust us, we'll make sure it works well. And I say, well, that's not how power usually works. We want the ability to know, to audit, to verify, to do things. And there are ways and mechanisms to properly balance the privacy interests of people with the need for transparency and accountability. So it's interesting to look at with this because Utah, in choosing to go this route with this amendment, they put a few things in place. And so to share a couple of these with you, this is going back to what the language looks like currently in the Utah Constitution. It says that all political power is inherent in the people, and they have the right to alter or reform their government as the public welfare may require. So again, Utah Supreme Court says, yep, you have that power. So the proposed language comes in. You can see what we just read here. This is the original language. The proposed Constitution Amendment D says people, citizens can amend it through the processes established in Article 6, Section 1, subsection 2, or through Article 23, as the public welfare may require. Article 23 isn't super relevant to this discussion. This talks about the amendment process, which we're doing right now, as well as actual revision of the Constitution through a constitutional convention in Utah. It's essentially saying they're not changing Article 23, but they do want to change Article 6. And so coming down here, we see, let's see. Oh, sorry. They're clarifying that you can change it to Article 6, which is the ballot initiative portion of things that says that's still something. But they add this in. to, I think, try and help people vote for it. They add in two things. First, they say foreign individuals, entities, or governments may not directly or indirectly influence, support, or oppose an initiative or a referendum. Now, from the text that we'll see in a minute of Amendment D, this appears that their goal is to say foreign individuals, foreign entities, or foreign governments may not directly or indirectly support, oppose, or influence these initiatives or referendums. But from my perspective as an attorney, it doesn't say that. It says foreign individuals, comma, entities, comma, or governments may not. So this could be interpreted to preclude groups like Eagle Forum, Sutherland Institute, any LGBTQ alliance, ACLU, others, from influencing, talking about, supporting, or opposing an initiative. Now that would be, from my perspective, unconstitutional to ban these entities from talking about things. But because it just says comma, entities, comma, this could be interpreted to be that broad. And groups could sue on that, trying to stop others from talking about things with initiatives. That to me is a concern. And then in addition to that, but again, if it's talking about foreign individuals, foreign entities, or foreign governments, I think it should say that. I think it should clarify that it's talking about foreign all the way through. And then it goes on to say, but even if we amend something, it says that the legislature has the ability to change anything that it wants. So it says specifically Article 6 here, but we can change anything we want. And the actions affecting Article 1, Section 2 and Article 6, Section 1 have retrospective operation. This means that it will apply to the gerrymandering issues and to the Supreme Court case. Now, one other thing that Utah did with this is they said, okay, but we'll put a little bit of protection in statute. And they say here that, so they changed this time. They'll give you 60 days to do a statewide referendum. So if this constitutional amendment passes, you get 60 days instead of 40 to gather signatures to repeal a legislative law. So referendums are one that are meant to repeal laws that the legislature passed. So that's one of the checks and balances. And they say instead of 40 days, we'll give you 60 days. They don't put that in the Constitution, though, so they could change this back at any time. And then going on down, it also says that the legislature, they're going to put in a statutory restriction, which again can be changed at any time. They say the legislature shall give deference to the initiative by amending the law in a manner that leaves intact the general purpose of the initiative. So even if the initiative's crazy, they're still supposed to leave in the general intent of it or the general purpose, but the legislature gets to determine that. It says in the legislature's determination what the general purpose of the initiative is. And then they can amend the law in any manner and determine necessary to mitigate an adverse fiscal impact of the initiative. Then it also goes on to grant a little bit of ability to put a stay on a law, where if you can get 25% of the number of signatures you need for the referendum, once you do that, they'll stay the law until you have a chance to gather the rest of them. So again, they're saying, okay, we'll give you a little bit of check and balance. We know you don't want to just give us power back without nothing. And so put that there. And so this only goes into effect though if this constitutional amendment is passed. So this is something that people then have to decide on to say, well, what am I going to do? Am I going to give the legislature back the power to change any crazy ballot initiative that comes through, understanding that by statute, they still have to give it deference and keep its general purpose in place? Or am I going to stand up and demand that they put in more checks and balances and increase things with either election transparency or other provisions that may be of importance? And this is an area that I admit it's a difficult decision to make. Part of it's based on your view of the future and which groups you trust more or don't trust more. If you trust the legislature to do the right thing, then you'll give them power, understanding that if you pass a ballot initiative, it can be done away. If you don't trust the legislature and want to work on reforms to put more checks and balances in place, and you vote no on this, you can have the power to pass initiatives that they can't change if they're altering or amending the form of government. And so this is a place that, again, it's a tough call, a tough question, and I expect there'll be people quite divided on it. For me, overall, I will be voting no, because I believe that the legislature needs to address checks and balances. And I don't believe this puts in place or speaks to appropriate checks and balances. I actually wrote an 11-page letter that goes in great detail through the different issues, the different concerns, and ways that perhaps we could better check and balance things. And so these are pieces that I feel are important enough to say, well, if we want the power back, we also want to have assurances that things are proper. We don't want things to just go crazy and give you more power than is necessary. And in the meantime, I know I'll have to work on ballot initiatives. If there's bad ballot initiatives that come through, I have to take the responsibility to educate people on those and stand up against those. But that is something that I still believe strongly in, the ability of people to make good decisions and the ability of people to speak and do things. And so for me, a fix to government needs to be a correct fix, not one that just gives them power with no checks and balances. I'm Austin Hepworth. I'm running for Attorney General in the 2024 general election, and I believe strongly that the law should be transparent and open to all Utahns. Thanks so much for joining me.